We, the jury of case number 2, Private Practice Revises Policies and Procedures Addressing Activities Preparatory to Research, have carefully reviewed the facts presented by the plaintiffs or patients and defendant, Dr. Johann Sebastian. Based on these facts, we find in favor of the plaintiff. Dr. Johann Sebastian clearly disclosed the patient's private and confidential information for research purposes without the necessary approval of the Institutional Review Board or the consent of the plaintiffs. Based on the defense's argument that disclosure was consistent with the common rule, Dr. Sebastian has failed to support this claim. His interpretation of this ruling states that with consent of the hospital, researchers are permitted to review identifiable information in order to develop protocol and to identify potential participants. However, we feel that according to the common rule, although recruitment is a necessary element of research, the Institutional Review Board must first approve the research protocol before any activities such as recruitment can take place. Further, according to the privacy rule, the only circumstances that would allow for such activities to take place without Institutional Review Board approval are when these researchers are employed directly by the entity. Although Dr. Sebastian's practice is the covered entity and is responsible for maintaining said records, he is not permitted to disclose the information to an outside organization. Therefore, we find that the protected health information of Dr. Sebastian's patients was disclosed to the contractor without any appropriate consent. Dr. Sebastian is also in violation of each patient's right to privacy and confidentiality, as he failed to take the proper precautions in protecting their identifiable information as enforced by HIPAA, the Health Insurance Portability and Accountability Act. This act states that without written request or prior consent of the individual, protected health information must not be disclosed unless it has been de-identified. This exception has not been met in this case, as identifiable information such as their name, their diagnosis codes, and their phone numbers have been disclosed. We feel that Dr. Sebastian willfully neglected to comply with HIPAA regulations and feel that he should be subject to the minimum civil penalty of $10,000 for this violation.